the recording. I'm going to apologise now. I do have a dog. I've tried to lock her out of this room, but she might bound in and she might bark. So I do apologise for that in advance. Joys of doing this from home. Okay, Scott, are we recording?
Yeah, we're recording now.
Okie dokie. Well, hello everyone that's here. Thank you for coming along to this session. My name is Parveen Tamadon-Nejad, and I'm a senior lecturer in law at the university. And one of my areas of specialism is intellectual property law. I've done quite a lot of consultancy work in IP for various industries, the entertainment industry. I've done bespoke courses for musicians, businesses. I'm also a contract lawyer. So this session will encompass generally the commercialization of IP. Now, obviously, I'm not sure what your startups are, what your businesses are. So I've had to be very broad with what I'm covering to make sure that I do encompass everything. So Murat's asked me, is there a chance during the presentation you're going to touch base on the dilemma where two people could have almost the exact same idea and how to manage the IP in that case? I think I might do that, Murat. I think I might. Okay, then. So that's a little bit about me. This session hopefully will be about an hour and a quarter, an hour and 20 minutes. Do feel free to post anything in the chat or ask me anything. The more interaction, the better. And with that, I'll begin. So what are we going to be doing in the session today? What is IP? What is its commercial value? How is it protected? And how is it commercialized? And as I said, I'll be doing those very broadly. So if you have specific questions relating to this, please feel free to ask me. In terms of categories of commercial property, you've got industrial commercial property, things like trade secrets and patents. And then you've got the intellectual side, the expressive side, which comes in the form of copyright and trademarks. And I'm sure most of you here will have at least one type of IP, that's attached to your businesses. Hopefully I'll cover all of those very broadly with you. What does IP cover? Well, it includes creative and innovative ideas. And again, I'm not sure where you are in terms of your businesses, whereabouts, how far along the line you are, whether you're at the setting up stage, or whether you've actually been operating for a period of time. So IP will try and protect those creative and innovative ideas. It's not always successful though, because some types of IP you can't protect the idea itself, and I'll explain that as I go through the session. So intellectual property rights, I've abbreviated them to IPR, are the rights used to use and protect intellectual property. In the United Kingdom, we have a very different system to the rest of the world because most of our IP doesn't need to be registered, and that's where the problems can arise. Murat and Michaela have asked me something similar about if two people come up with the same idea or whether somebody nicks your idea, for want of a better word. How do you protect that? Well, actually, it's quite difficult under UK law to do that. Obviously, if you're expanding into the global market, then you may have other forms of protection within other jurisdictions. But for today, I'm only really talking about the United Kingdom. So IP is a power tool for economic development and wealth creation that is not yet being used to optimal effect in all countries, particularly in the developing world. And again, this is another issue. In developing countries, that there are no IP protections, there are no IP laws, so exploitation is rife in some areas. Commercialization and exploitation can be very, very positive. So when I talk about the commercial exploitation of your IP, I'm using that terminology in a very productive way. So to exploit your IP is to make money on your IP. But it can also be negative if you then exploit somebody else's IP, you take their IP and they get no kind of financial compensation or recompense for it. So what is IP? So intellectual property, it sits in the middle of everything. It's about innovation, it's about business, it's about law. Years ago, as a contract lawyer, you would never see an IP clause in a contract. What did that mean? It didn't really exist. Then suddenly, intellectual property became a real issue. and people wanted to try and protect it. So one way that you can protect your idea is through contract law. And I'll talk about that in a little while. So IP sits at the centre, but it's very much governed by innovation, about your creative endeavours, your creative ideas. It's to do with the business, and the business and the IP can be very, very separate things. Okay, so you might sell your business, you may sell your IP and keep your business. So there are ways in which you can really exploit your IP, but all of that will be governed and legislated somehow. Okay. Why protect it? Okay, so one reason to protect it is to prevent plagiarism and theft. But as I've said, it's very difficult in the United Kingdom to try and stop others from stealing your intellectual property. And it depends on the type of IP that we're talking about. It could be a patent, it could be a design right, it could be copyright, it could be a trademark. Some of those are much easier to protect than others because the legislation in this country is far more robust. But for example, we'll come on to copyright in a sec. When we look at copyright, you'll realise, hopefully, that it's actually really difficult to protect copyright. I'll explain what copyright is and how it works. The other thing about intellectual property, it prevents others from using it. Okay, so if you think about intellectual property, it's property that belongs to you. It's your creation, it's your innovation, it's your design. So you then have the right, theoretically, to stop other people from using it unless they have your permission to do so. And you can give your permission in the form of a license, in the form of a royalty, etc. The other thing is to prevent others using it for financial gain. There's nothing more annoying than somebody taking your work and making money on the back of it when you're not yourself. And I don't know if you've been aware of what's been going on with Spotify and musicians arguing that Spotify are playing all of their music, but those musicians are reaping no benefit or no reward from that. Okay, we pay a fee, we pay $9.99 a month to use Spotify. Where is that money going? If it's not going, some of it isn't going to the musicians themselves. So that's very frustrating. So hopefully IP can be used to prevent others from seeking financial gain. Again, it's to generate income. Businesses can sell part or all of their IP. They can exploit their IP. They can license their IP through the use of exclusive licenses, non-exclusive licenses, and other forms of licenses that brings money in the same way that you can rent out your house. So if I want to go off abroad for a year, chance would be a fine thing. But let's say I wanted to go into the sun for a year, I could rent my house out for that full year and I could make financial gain on it. But at the end of that year, the house comes back to me. So with your IP, you can license it or you can assign it. And if you assign your IP, it means you give up the right to use the IP yourself. In the same way, if I sell my house, I may still have a key, but I can't come back into this property because I've sold it. So there is a distinction between licensing and assigning your intellectual property. So you need to be aware of what it is you actually want to do. But you can generate income by doing either or both of those things. And then, of course, to increase value of the business. So all of you here with your startups, you know, one of the most important things is the business name, because that's what's going to get your business noticed, whether it's online or on the high street or wherever it is that you're operating from. I need to know where to go to get your goods or your services. So your trademark, your company name, whatever it is of value. Okay, and then whatever else it is that you do with your business. If you're if you've invented something, then the patent is going to be really, really valuable. So those are the legal justifications for protecting your IP. We've got different categories of IP, and I'm going to go through these with you today. Some of them may be relevant to some of you. Only one of them may be relevant to some of you. But again, as I've said, because I don't know what type of businesses that you've set up, I'm just going to give you an overview of each of the different types of IP that exists legally in the United Kingdom. Okay, so the first one is copyright. All of you will have some kind of copyright attached to your business, whether it's in the form of a website, whether it's in the form of words to use to sell your product. All of you, copyright will attach to your business in some way. Copyright consists of things like literary works, artistic works, multimedia material, broadcasts, films, that kind of thing. And I'll go into those categories in a little bit more detail in a sec. Then we've got confidential information. It's not really a type of IP, but it's one way of protecting your idea before it becomes the invention, before it becomes the artistic work, before it becomes the design. So it's a concept. You have a concept for your business. How do you protect it? Because the law does not protect ideas. It's really, really difficult to protect an idea unless it's fixed in some way. And by fixed, I mean, is it written down? Is it recorded? Is there a painting of it? So your work has to be fixed in some way before it can be protected. But before you get to that stage, you want to go and maybe you need to raise money from the bank. If it's a patent that you want to raise money for, you will not get patent protection if the patent is in the public domain. And the public domain can be one person knowing about it. So in terms of protecting that idea to raise the money or the capital on it, you need that information to remain confidential. So how do you do that? Well, we do that through contract law. So that's another type of IP. Then we've got patents. Patents are inventions, new products, new processes. I'm not sure whether that's relevant to anybody here today. Designs, external appearance of products, the wheel arch of a car, for example, the shape of the table, the shape of the chair, the design of the product. All of these are separate categories of intellectual property, and there are different laws that attach to protect them. Okay. And then trademarks. So obviously that's the logo, the brand, the image that you are using to sell the product, the goods, or the services. So I'm going to be looking at those areas or those categories of IP in a little bit more detail as we go through this presentation. Then I'm going to be looking at the commercialization and how to exploit these. Any questions so far? Michaela, put my specs on. What about a digital platform? Is that classed as IP? Absolutely. So it can be copyright protected. There can be a trademark. So digital platform is a different type of multimedia. So the law always plays catch up with IP. So once upon a time, we only had the written word. It was printed on paper. So if there was any kind of copyright infringement, we'd be looking at, you've copied this from this piece of paper or from this newspaper or from this book. Now we have digital platforms. We've got social media where people upload, people copy, people send, people share. Okay, and now the law has played catch up, and we can protect to some extent. If you upload something onto social media or to a digital platform, it should be protected in the same way as any other piece of work. I will need help with that in the future. Okay, then. So if you've got any specific questions, I will try and answer them this session, but obviously it might be very, very specific. So we can have a chat later or afterwards or next week at some point, Michaela. So as I've said, if anybody's got anything which is really specific to their business, which obviously I can't take time to answer in this 2-hour slot, then contact me. Scott and Lisbeth will have my details. Contact me. If I can help, I will. Okay. You're welcome. So we've got the creation of intellectual property. On this site here, these rights, I've called them automatic rights because they arise automatically. You don't need to register them. So copyright, trade secrets, know-how, which is confidential information, database rights, design rights, and brands, they're automatic rights. So if you create them, then the ownership, the IP belongs to you. Now, the problem with that is it's your word against mine. And I think both Murat and Michaela have asked me about somebody using your information, stealing your idea, or two of you coming up with exactly the same idea. Who then gets the protection? Who then has the right to use that IP? Well, unfortunately, under the UK law, but both of you will have the right, but neither of you will be protected. So if you and I come up with exactly the same design right, and neither of us can prove I came up with it first or you came up with it first, because it's an automatic right, there's no legal requirement to register it, then the law says, sorry, can't help you. So I'm going to either have to sue you for stealing my design, but that's going to be really, really hard to do. So what the law says is you both have the right to utilize it, but the law's not going to protect either of you unless one of you can prove that you were the first person to think or create or have this idea. So those rights on the left are automatic rights, meaning no registration required. On the other side here, under formal registration, you have to register a patent, you have to register a trademark, you have to register your designs. Now then, on the left-hand side, you've got unregistered design rights, and on the right-hand side, you've got registered design rights, and they're slightly different. So if I want to protect my patent, I'm thinking of the AstraZeneca drug or Pfizer. So big pharmaceutical companies will register their patents for their drugs, and the registration or the protection starts as soon as they register. So if I register my drug on the 1st of June 2021, my protection starts from that point onwards. I could get rejected 2 years down the line, it doesn't matter, but my protection starts from then. And it's much easier to prove then. So if somebody else comes along and infringes my patent, then I can prove, well, I registered it on the 1st of June 2021. So there's a formal bureaucratic process. So patents, trademarks, and registered designs must be registered. If you don't register a trademark, that's fine, you don't have to. It just means that somebody else can come along and use the same trademark as you. Then you've got to fight through the courts under what we call the common law, meaning that it's your word against mine, whereas if you've registered it under the legislation, you've got statutory protection. Hope that makes sense. And statutory protection is much more robust. Basically, you're protected. Okay. So let's look at copyright first. I'm going to just briefly go through what copyright is. And again, any questions, please pose them in the chat or put your hand up. You will notice the C in the circle, okay, and most people think that means it's registered. It doesn't. That is completely bogus in the United Kingdom. Because we do not register our copyright here, we use that as a deterrent in the hope that people that don't know anything about English law will think, oh, can't use that because it's copyright protected. Okay, it will be copyright protected because it's your work, but your work arises, your copyright arises automatically. So the moment I put my slides together on my laptop and I put my slides together, my work is protected because I've fixed it, I've recorded it, and it's there on the screen. It's my own original work, and it's there. So if anybody then wants to utilize those slides without my permission, it's an infringing action. The problem is, how do I prove it? Now, in the US, you have to register your copyright. So I don't know if people are thinking of branching out into the US, but in the US, you have to register your copyright. So again, it's much easier to prove out there. But in the United Kingdom, no registration, it's an automatic right. It arises the moment your idea is transferred somehow. Now then, it has to be an original work, meaning it has to come from you. You can't have nicked it from somebody else. It has to be recorded somehow, and by recorded I mean you can either write it down, you can film it on your phone, you can record it on your phone, you can make slides. If you're an artist, you have to paint it or make a sculpture. If you're an architect, you have to do a prototype of the building. So recorded means different things depending on the type of work that we're discussing. There are a number of different categories of works. The Act, the Copyright Designs and Patents Act, says a copyright work is a literary work, a dramatic or musical or artistic work, a film, a sound recording, or a computer program in some instances, and databases. So those are the categories of works that are protected. So as soon as you put your database together, the right is automatic, it's protected. As soon as I write my play, my novel, it's protected. As soon as I put my paintbrush to canvas, the work is protected. Okay, so you've got 8 categories of work. Now, all of you in your businesses will have words, whether it's to do with explaining what the company is. It could be, for example, IKEA. I'm thinking about IKEA now, thinking about, oh gosh, I haven't been there for years, and how I really don't like going there because everything's flat pack and you have to build it yourself. But the instructions are a literary work and therefore are protected. So an instruction manual will be protected as a work. So it doesn't have to be a work of any great, amazing, I don't know, it doesn't have to be the best book, the best painting. It just has to be an original work. So it comes under one of those categories and it's recorded somehow. And as soon as that's happened, then the copyright attaches, and it attaches to the author. And in this instance, author is the person that creates it. Okay. So if you've got something online, let's say, you've got a digital platform, going back to what Michaela asked, your digital platform, all the text that's on that digital platform will be protected as a literary work. The way it's set out, the font you've used, the layout of it, that's protected as a literary work. The fact that it's in a digital format doesn't make any difference. It's the same principle as if you'd written it on paper or in a pamphlet or on a leaflet. Okay, so that's what copyright protects. The C in the circle is meant to put people off, to think that they can't use it, which again, it's true, they can't use it, but you don't register your copyright in this country. So if two of you have created the same work, let's say you and I both write the same song, similar lyrics, the same tune, and both of us upload it onto YouTube at the same time, then the law's going to say, well, which one of you came up with it first? Which one of you recorded your YouTube first? And if neither of us can prove it was us, then it means, well, we won't be infringing each other, okay? And that can be quite problematic. I've done some consultancy work for the masters, the fashion students, in terms of the prints that they make in their fashion collections. So you'll see it on the runway in Milan on Tuesday, and then Topshop the following Monday. How can they get away with it? Well, you can't protect a skirt or a shirt, but the design, the print that goes on it is what's protected. Okay, so if they vary it, it still could be an adaptation of a work, which means it could still be copyright. There could still be copyright infringement. There are certain ways that you can protect your prints in that way. It's a fickle industry, though, unfortunately. The same with music. Because you have genres of music that sound very identical, if you're writing a rock tune and somebody else then sues you for infringement, it's going to be quite difficult to prove unless it's very, very specific, that you've taken the lyrics or the tune from this song and used them in another song. So when sampling became a thing, there was a lot of court cases because artists were arguing they've used my song, my words, and then sampled them in something else. So the whole idea of sampling in the 80s was great. What a great musical invention. But then it just caused a raft of litigation, which, yeah, there's still ongoing issues. But that's a separate argument. Okay, so that's what copyright protects. Those works listed. There's just some examples. A cover of a book, great film and a great book one day. That's a poster for, oh no, it's a painting. So a painting is a work. Google, all the social media platforms are protected under the law of copyright. So they're protected as literary works. And if there's any pictures, then artistic works will attach. That's Anthony Gormley's sculpture, The Angel of the North. That's protected as an artistic work. That's a poster for an exhibition. That's protected as a literary work. And then that's a list of students. That's a database. That's also protected. So just examples of what constitutes a copyright work. So it's really very, very varied. So as I've said, it's automatic. So you don't register it. So there's no fees. Hurrah. Which means it's dead cheap because it's free. There's no bureaucracy. There's nothing worse than paperwork. So there's no paperwork to fill in. You do get worldwide protection. Now, particularly now everything's online, you are protected. So if your copyright was instigated, if your copyright, it was an automatic right and you created it in this country, then if anybody infringes your copyright work in France or Spain or the US, it comes under UK law. Okay, because it's the author of the work and the instigation of the work takes place on English soil. If you were then to create your work in France and there was infringement of your copyright, then you'd have to look at French laws to protect you. Okay, so it's important that the country of origin is where the jurisdiction takes place. Okay, so those are the pluses of copyright being automatic: no registration, no fees, no bureaucracy, and worldwide protection. Again, so to make it really clear, copyright only protects the work, not the idea behind it. So I've got a great idea to write a song about the pandemic. Can't protect that, it's just an idea. I can tell you about it. You can go and write a brilliant song about the pandemic. Nothing I can do about that. It's as soon as I record it, then the work is protected, as long as it's an original work, meaning it's my own creative endeavor. So as soon as I fix or record the work, then the copyright attaches. So we can all have an idea about setting up a business, and it can all be exactly the same. We're all going to sell coffee. What a great idea. Great. But copyright will only attach to the text or the literary work that we use to sell our company or to sell our coffee. The fact that we all want to sell coffee, that's fine, because we live in a world where competition is good and healthy. Okay, so the idea is not protected. It's once the idea is recorded and fixed in some format that the right arises. Copyright, so we're still only talking about copyright here. It doesn't protect non-works. So if you go back to the previous slide, there were 8 works listed, which is what's protected under copyright law in this country. You cannot protect names or commonplace names or insubstantial items under the law of copyright. Okay. It doesn't protect works without merit, meaning again, it has to be your own original work. Okay, so it could be the worst song in the world, the most appalling painting, doesn't matter. As long as it's an original work that's been fixed, the law will protect it. Okay. So what constitutes an infringement of copyright? So that list there are all the things that the author or the owner of the work can do. And if anybody else does any of those things listed without permission, it's an infringement. So copying, if it's straight copy, that's an infringement. You can't adapt somebody else's work. So for example, you've written a song, I adapt it slightly, that's copyright infringement. And it doesn't have to be the whole song, it can just be part of the song. If you copy from somebody else's work, this is an important thing. You don't have to copy everything. You only need to copy some of it. And that can be, you know, it may not be a huge chunk anyway. You can't issue, lend, or rent. So for example, if I invite all of my mates around to watch something that I've downloaded illegally, shh, don't tell anybody, onto my laptop, I'm not in public, am I? I've invited 10 friends round, but I'm still doing it in public. And that can be, that theoretically can be an infringing activity. So I can't issue it to anybody else. I can't lend what I've downloaded illegally to anybody else, and I can't rent it. Even if I make no money from it, it's still an infringing activity. I can't broadcast without permission. All of those will amount to infringement. If it's done by a third party to the whole or the substantial part of the work, it's an infringing activity. So again, you only have to copy or adapt or issue or rent or lend some of the work for it to be an infringement. Okay, so as the author or the owner of the work, you could do all of those things. If anybody else does those things, then that's against the law. So if you come across something and upload it onto your website without permission, that's an infringing activity. So you need permission to upload everything, even if you find it on the internet. Just because it's on there doesn't mean to say you have the right to use it. Now the problem is the social media platforms are very reluctant to get involved until they let them get involved. So if somebody is infringing your copyright and uploading it onto Facebook or TikTok or whatever social media platforms you use, and you inform that social media platform, they have to remove it. Okay. So the laws become a little bit more stringent in that area there to protect, because there's so much sharing that goes on. Obviously, Snapchat on your phone. I mean, I don't know if you're aware of Snapchat, but I mean, you know, and they only last. If I send a picture on Snapchat, it's 10 seconds and then the picture's gone. But if I take a screenshot of that picture and I keep it on my phone, that's an infringing activity. Okay, so the law has to play catch up in terms of technology, because we become much better copyright infringers as technology increases. Not us, obviously, I mean others, clearly. How to protect a copyright work. Okay, so this is very hard to do because it's an automatic right, there's no registration, so it's your word against mine. So there are a number of things that you can actually do to protect your work. You can have a statement. So whatever the work happens to be, make a statement with your name or your employer, if you're an employer, the year, the date, make it very clear that on this day, this year, this work was created by you, and then lodge it somewhere. So you can lodge it with the bank, you can lodge it with your solicitor, and that establishes the date that that work came into fruition. Okay. And that's really, really important. The composer Andrew Lloyd Webber was sued a number of times for infringement of his musicals, people saying that's my work, you've stolen that from me. And every time he writes something new, he sends the libretto and the manuscript off to his solicitors, he dates it, it's not opened, it's there, and if there's any legal recourse, then the solicitors can say this arrived on this date, let's open it, oh, it's the manuscript for his latest musical. That helps prove that on that date you had written that piece of work or painted that painting or whatever it happens to be. So you can, that's one way of protecting your copyright. So it establishes the date the copyright work existed. With software and electronic materials, please don't ask me about this because this is a bit electronic-y, but what you can do is there are encryption methods, technical methods that you can input into the software program that proves it's yours. So what happens is, if I copy your computer software program and it's identical to yours, and you're arguing, well, that's mine. I mean, I could just say, well, I've created this years ago, it's mine. But if you were to put something in that software that doesn't make any sense, if I copied it, that same glitch will appear for no apparent reason. So that will prove that it's yours and I've copied it. Okay, I don't know how you do that. Apparently that's one way of doing it. So with software and electronic materials, there are other methods, technical methods that you can do to protect your work. It won't stop it from being copied, but you'd have a strong argument to say, well, it's mine, it's been copied because this technical glitch was put in deliberately. So if anybody copies it, it will appear in theirs as well. Okay. A license agreement allows you then to license your work to whoever you want it to. And that means that they are allowed to use your work because you've given them permission to do so. And obviously, you're going to make some financial gain from doing that. I'm going to look at licensing agreements later on. Okay, that's copyright in a nutshell. It's like a whistle-stop tour of all of the different types of IP. Any questions about what we've covered so far with copyright? If you think of anything, as I say, just post it in the chat. That's absolutely fine. So the next category of IP that we're going to look at briefly is confidential information. What is confidential information? How can you protect it? When I talk about common law, I'm not sure whether your knowledge of English law, but the common law system is where the judges decide the outcome of a case. So if it's an infringement of copyright, or if it's me suing you for breach of confidential information, it goes to court, and the judge will decide the outcome. However, if you infringe my trademark, it will still go to court, but the judge will look at the act and come up with a solution. But under the common law, he or she has to look at previous cases to decide the outcome of our case. So it's quite a different system to other European and US codes. The duty of confidentiality is strongly enforced. So it's understood under the law that some information has to remain private. So the law categorizes what it believes confidential information is. So it's about the information rather than the business. So you have a business, I have a business. The law doesn't care about us, it cares about the information that we're protecting. And if that information fits within the definition of what the UK laws say is confidential, then we will be protected. If it doesn't, that's a much more difficult thing. So what constitutes trade secrets will vary from business to business, but it's things like your customer list, your pricing policy, distributors, that kind of thing. If a third party receives that information, so if I'm an ex-employee and I go and work for somebody else and I pass on this confidential information, then in some instances the law will say that third party will be responsible or liable, because they should know that the information being passed on to them is confidential in nature. We have no law of privacy in this country, so we cannot protect under privacy laws because they don't exist. So we have to looking at confidential information to protect what we believe to be confidential for our businesses. How does the law, because we're talking about intellectual property here, so excuse me, confidentiality has to be termed a property to be protected. So how is confidential information a property as such? Because it's intangible, I suppose, like all IPs. So trade secrets. So what constitutes a trade secret? For example, the recipe of Coca-Cola, for example, that could be a trade secret. Financial information is a trade secret. Customer lists is a trade secret. Then we have know-how, knowledge and skills. So in the workforce, know-how is something which only certain people will have access to. So maybe you've been employed, or you're employing somebody to work on a specific area of the business. You want them to create a computer software code for your business. They're the only ones working on it. They have what we call know-how, meaning that what they're working on will be deemed confidential information. And if they go off somewhere else and then do the same thing for another company, you potentially can sue for breach of confidentiality. But I will say this. If you commission somebody to do something for you, and this is generally not just in terms of confidential information, if you commission somebody to come in and create something for you, be very careful whether it's a contract for service or a contract of service, because with one of them, the IP goes with that person, which means they can take the IP with them. With the other, it means the IP stays with you. There's been a number of cases where people have been commissioned to do things, and they've gone away and taken their IP with them, whether it's a software program or a design for, I don't know, Doc Martens is a case that springs to mind, where the guy was employed to design a type of Doc Marten boot, and then he went off to another company and did the same thing. It was a big Australian and US and UK case at the time. So be very careful that you make it clear that the IP whatever it is they're working on, the IP stays with you if that's what you want. Okay. So confidentiality as a central tool of commercial exploitation. Legally essential if ideas are to be patented. So again, if you've got an invention and you want it patented, you cannot patent anything that's in the public domain. And in the public domain can mean one person knowing about it. So if you need to raise money on an invention and you want to keep that information confidential, you have to have a non-disclosure agreement. Okay, you have to get the other parties to sign a non-disclosure agreement or confidentiality agreement, which means they cannot talk about the information outside of that meeting. And they are fairly common and standard in this kind of setting. So commercially essential in other areas of intellectual property. So again, if you're raising money and it's to do with copyright and work, you know, a confidentiality agreement is really, really important, because if it's just at the idea stage and you haven't fixed it, then you can't protect it. And a case that springs to mind is Fraser and Thames TV, where a guy, and this is common in the industry, he's got an idea for a TV show. He goes along to all the major TV companies to pitch his idea. He's rejected from all of them. And then ITV take his idea and make a TV show out of it, which is hugely successful, and it wins loads of awards, etc., etc. And he sues for breach of confidentiality. And the court said, yep, in that instance, the TV company should have known that the information was confidential, and there's no other way for him to protect his work. There's no other way for him to sell his script. So it was a literary work. He was going there, he was telling them his idea for a TV show. There was no script as such written down. So he was merely explaining, this is an idea for a TV show I have. So you can't protect that. You can't protect that idea. As soon as it becomes a script, it's protected as a literary work. So the courts understood the importance of confidentiality and confidential information. So it does protect other types of intellectual property. It's an evidential tool as well. If you have a non-disclosure agreement, it proves that at that time when the contract was put together, the idea or whatever it happens to be was yours. And as I said, it's accepted business practice. So don't be scared because it's a contract. You can download non-disclosure agreements online. Maybe some of you have done that, but don't be afraid to make people sign it before the meeting, please. Otherwise, it's useless. So they have to sign the contract before you go and explain what your idea is if you're raising money. Okay. So that's confidentiality, confidential information in a nutshell. It broadly protects information, and it depends on the business that you've got. I mean, as I said, I don't know at what stages you guys are with your businesses, but if you're at the inception stage, think about a confidentiality agreement if you want to raise capital or you just want to discuss ideas with other people. Patents. Yeah, patents. Patents make huge amounts of money. The problem with patents is they're so expensive. So you have to make sure you've got enough money in your bank account if you want to patent an invention. They protect new technical concepts and inventions. You have to register it if you want it protected. It gives you a 20-year monopoly from the date of registration. So from the date you file your application, the 20 years starts from there. In this country, it can take up to 2.5 years for your patents to be granted. It really does depend on what type of invention it is. Patent lawyers have to have a first degree in engineering, so they're very technical, the patent application forms. And if you get it wrong, you can't just amend, you have to do the whole thing again. And a patent can cost a few £1,000 at the very bottom of the scale. So, you know, that's why with a patent, with an invention, you need to raise the capital first before you put in your patent application, because it's going to cost you quite a lot of money to patent it. Conceptual protection, it protects products and processes. You can only get a patent in a specific territory. So if you apply, you can apply for a patent just for the UK. It costs you a lot more, but you can also get a European patent. Now, I don't know what's happening with Brexit. Please don't ask me what's going to happen to all these laws now that we've left the EU. But at the moment, everything's still in place. So if you wanted to apply for a European patent, you could. Or you might just want to apply for a patent in some other country, i.e. Japan, and you can do that. If you have a patent, and you apply for a patent in the UK, you will only get protection for it in the United Kingdom. That's the other downside as well. Statutory requirements. Your invention has to be novel. It has to be non-obvious, involve an inventive step. I mean, as entrepreneurs, you're not inventing anything completely new, you're changing something. So in terms of novel and an inventive step, it's taking something like a phone and making it a computer. That's the inventive step. So a phone already exists, but the apps that go into the phone are the inventive step. That's what makes it different. You know, if you remember back in the day when mobile phones first came out, all you could do was make phone calls. You couldn't send texts. So the next technological step, the next inventive step, was being able to send messages, then taking photographs, etc. So you're taking something for a patent to be granted. It has to involve the next step, if you like. It has to be capable of industrial application. You have to be able to make it. So it can't be a scheme or a formula. You can't patent a formula. So it has to be something that you can actually make. And it must not have been in the public domain anywhere at any point, okay? That's why it takes so long for a patent to be granted. It can take up to 2 years because all of these checks have to be done before the patent is actually granted. but it can be revoked at any time. So you can have your patent granted, 5 years later, somebody can come along and sue you, and you can have your patent revoked, which is why you must have money to be able to potentially fight off any legal claims. Patents can be valuable. I mean, the university makes more money from its patents than it does from its students, because we will license patents, you know, in some of our departments. So patents are a huge area of revenue. So it stops others from using an invention, i.e. the unlicensed manufacture, the use, the importation or sale of patented inventions. So this is a really, if you look at the pharmaceutical industry, for example, in developing and third world countries where malaria is rife, those third world countries cannot afford the anti-malarial drugs that come from the West, but they can make their own at a fraction of the cost. But because there's a patent on those drugs, they are prevented from manufacturing their own version of the drug in their own country at a much, much cheaper price. And in my opinion, that's pretty immoral, but that's how patents work. So they're hugely valuable. You can take legal action against others who might be infringing the invention, and you can claim damages. You can let others use the invention under agreed terms, licensing an invention to let others exploit the invention and pay royalties under a licensing agreement. So the term royalties is used across the board in terms of IP. It's revenue that you can gain from licensing your work. But as I said, patents are hugely expensive if you want to patent your invention. But this is the other thing. Once you apply for a patent, it goes onto the register. Okay, so whilst your patent is, you're waiting for your patent to be granted, it's on the register and anybody can see it. So your competitors can see what it is you're working on. Then if your patent is rejected, they've had a look at what you're doing and they're already manufacturing, you know, the next stage, the next step. The scope of the written application covers the commercially important elements of the invention. Okay, you have to get professional help if you've got a patent that you want to apply for. It's a really technical process. And as I've said, the form is really, really, really in depth. And if I'm applying for a patent for a phone, it's not the whole phone, it's just aspects of the phone that I want the patent to attach to. So you need somebody that knows exactly how to fill the form in, because if it's rejected, you have to start again, and that's another 10K that you might have to fork out. The owner has the means and can enforce the patent, meaning if somebody challenges you, you've got the means to be able to sue in the courts. Otherwise, you've lost. People would then just infringe your patent because you don't have the tools to fight back. The state neither polices nor enforces it, so we don't have anything to do with that. There's a patents tribunal that you can attend if somebody's infringing your patent, but it's up to you to sue the other party. The law doesn't get involved in that sense. You have to pay for the application and its upkeep. Each territory incurs its own costs. So again, if you've got a patent in multiple territories, then those laws apply in those territories. And there is a clear, profitable and accessible market demand for the invention. Again, so you need to know your market. And I don't know if any of you have got patents or patents pending. If you watch Dragon's Den, and I don't know if you watch Dragon's Den, but that's a really good example of how they work, because most of the time the dragons will ask, have you got a patent pending? Meaning, is your patent protected? Because you've now come on TV and you've told the whole world what it is you want, what you want money for. So again, you need to have some coffers in the bank if you're thinking about patenting an invention. But if it's worth it, it can be hugely commercially exploitable. You can earn a small fortune on the back of it. Okay, then moving on, design rights. There are two types of design rights: registered designs and unregistered design rights. I'll just go through those very briefly. If we're looking at the Registered Designs Act 1949, you must register your design, okay? The design is all about the external appearance of the design. you get a monopoly of 15 years, which is the same as a patent, although with a patent you get 20 years. There has to be something novel about the design. You get a 12-month grace period of applying and it being granted. It can be renewed every 5 years, up to 25 years maximum. Okay? And it's an alternative to copyright and patent protection. So, for example, artistic works under copyright are very specific as to what constitutes an artistic work. For example, a sculpture, a building, a painting, a photograph. These are all artistic works. If I've designed a beautiful sofa and it's very unique, I can't protect it under copyright. It doesn't fit within the definition of an artistic work. I can then register it under the Registered Designs Act 1949. So I can still protect the design of my sofa. Even though I can't protect it under copyright, I can protect it under a registered design. So it depends what it is and under which one you'll get protection from. But you can't protect a piece of artwork under the Registered Designs Act 1949 because it wouldn't fall within the definition of what a registered design is. So UK design registration will protect the lines of the design, the contours, the colours, the shape, the texture, the materials of a particular product or the decoration of a product. So I'm thinking about cars, you know, the wheel arch or the back bumper of a certain type of car, which is very unique to that car or that make or that model, can be protected as a design right under the UK. And again, if it's a specific colour for a specific car or a specific sofa, that can be protected. So Jessica has asked me a question. I translate patterns from films and cinemas into my own textiles. Interesting. For home furnishings, what rights do I have to protect my interpretation of these patterns? Right, that would come under copyright as an artistic work, because it wouldn't come under lines or contours. That's more 3D. So the design will protect it's more 3D and it's functional. So a design has to be a functional design, whereas what you're talking about is patterns from films and cinema. That sounds interesting. Onto textiles. Textiles in their own right will come under artistic works. So if you look at under Section 4 of the Copyright Designs and Patents Act, it lists what constitute an artistic work. So that's how you would protect it. But again, you wouldn't be able to register it. But you should be able to prove when the fabric came into fruition. So you can maybe take a photograph of it, date it, and say, this is when I created this piece of work. Michaela's asked me, what if you wanted to make a documentary? Well, that will be protected as copyright because it comes under films, sounds, and broadcasts. So that will come under copyright protection. So as soon as you start recording or you've recorded the documentary, it's protected, because it will be very easy to ascertain the date on which the film was made. But the build up to that, the idea behind the documentary, you can only protect that if you've got a confidentiality agreement. So the idea behind the documentary itself, the way that you want to film it, where you want to film it, all that kind of thing, that's what makes it unique, rather than, I don't know, the content of what you want to make your documentary on. But let's say you want to do it on the pandemic, that's pretty broad. I mean, we can all make a documentary on the pandemic, but your take on it is what's unique or original. So as soon as you start recording it, that's it protected. Yeah. So going back to registered designs, it protects the appearance, not the technology. The technology is protected via a patent, whereas the appearance is protected as a registered design. You're looking at the shape, the pattern, the ornament of an industrial design. But again, this is where it's different from yours, Jessica, because it's 3D rather than 2D. Not to be dictated by function alone. So it is not only is it functional, it has to have what we call eye appeal, and it must have an aesthetic quality to it. So if I take a box standard chair, that wouldn't have eye appeal. But if I take the shape of that chair and do something more with it, then it could be registered as a design. Well, that's very small, isn't it? Effect of registration. So what happens if you register it? Well, it prevents another person from using or registering a similar or identical design, irrespective of intention. And what that means is, yeah, I mean, you've come up with something very similar to somebody else's, you've registered it. There's no underlying malice behind what you've done, but it will protect the person that registers it first. And it gives control over assignment and licensing, the right to sell and exploit and license the design itself. It gives you, the person that's registered it, that right. If we look at unregistered design rights, this was introduced in 1988. We're looking at industrial design, 15 years maximum protection, 10 years from being first marketed, automatic and no costs. Okay, so the difference there is this. It's the same with the trademark. For whatever reason, you haven't registered your design. Maybe it doesn't have eye appeal in the same way, but you can still have it protected under the common law if somebody copies your design. It's harder to prove because it's not protected by statute, but if for some reason it doesn't fall within the definition of the 1949 Act, then obviously you can still design it. It doesn't stop you from designing it. It just means that if anybody copies it, you have to go through the common law route of proving infringement. Okay, and one of the main reasons it's not going to be registered is maybe it doesn't have eye appeal. It's not aesthetic for the purposes of the Act. Okay. Main benefits of design, protection, registered and unregistered, valuable assets. All IP is a valuable asset. It gives exclusive right to make, import, use or stock any product to which design has been applied. It's a marketing tool, branding the company's products and image. Again, so think about IP as branding the company, and it's a marketing tool. You know what, when companies go into liquidation, this is one thing that I've learned over the years. When companies go into liquidation, you've got all the tangible assets, maybe the building, maybe the stock that goes within the building, the desks, the chairs, the computers. However, once you get rid of them, it's the intangible assets, the IP, that can sometimes be far more valuable, the trademark, the patents. Okay, so never ever assume that your IP is not as valuable as your tangible assets that your company has. Okay. This is something that all of you are going to, you'll all have a trademark or some kind of company logo. Whether you register it or not is entirely up to you. You may not be able to register it as a trademark because it's your own name. So the law, you can't trademark a name. If it's your own name, you can still set up your business using your own name, but you can't register it as a trademark. So if somebody, I've got Jessica there, Jessica Lewis Tatton, she sets up her business calling it Jessica Lewis Tatton. I then set up another business and I call my business, weirdly, Jessica Lewis Tatton. She can't sue me under the Trademark Act because you can't register a name as a trademark, but she can sue me under the common law of passing off, which is an unregistered trademark. It's similar to registered designs and unregistered designs. So what is a trademark? Well, it's a symbol, a brand or device put on goods or used in connection with a service to identify and distinguish them from the goods and or services of competitors. A registered trademark gives the right to use the, I can't see, can you see that? It's the R in the circle. If you see the R in the circle, it's a registered trademark. When you see the TM, it's an unregistered trademark, but it acts as a deterrent in the same way as the C in the circle. Because if you see TM, you just assume automatically that it's a trademark and you're not allowed to use it. So if it's a registered trademark, it gets the R in the circle. If not, it's the TM. Here are some examples of trademarks. Now then, the Nike swoosh. What a brilliant, brilliant trademark. How simple. You don't even have to see the word Nike. You know exactly what that is. Great piece of marketing, that. Virgin, you can't trademark the word virgin. You can't trademark the word puma because these are common words. But virgin in that font, in that colour, in that design is a trademark. The same with puma. You've got the name Puma and you've got the logo, the image of the cat. That whole image there, including the word, is a trademark, but you can't trademark the word Puma. Coca-Cola, they did try to trademark the shape of the bottle. Coca-Cola is a made-up name, so they can trademark that. McDonald's can't trademark the name McDonald's because it's a common surname, isn't it? So you can use if your name's McDonald, you can use McDonald's to sell your product. What you can't do is use the golden arches on that red thingy, on the red plinth, because that's the trademark. Pepsi is a made-up word. Bass is a word, but written in red with the triangle is absolutely fine as a mark. So the differences in protection. Under the Trademark Act 1994, if you can register your mark as a trademark, because it's not a name, it's not your name, for example, it gives you registered trademark protection. All you have to do is to prove that somebody is using your mark without your permission, and then they fall foul of the statute, and you can claim damages. Passing off is different because it's an unregistered trademark. So my company name has been used, somebody else is using it, they're passing themselves off as my company. What do I have to prove? I've got to prove goodwill. I've got to prove that the goodwill means that my business has been operating and that customers know my business. They know what the goods and services are. I don't have to be operating for many, many years, but I just have to prove that I am actually trading under that name, and that I was trading before this other person started to use my company name as theirs. So you don't have to register a trademark. It's really cheap, actually. If you want to register a trademark in this country, you're talking a few hundred quid. It's not a lot, and it's a really easy form to fill in as well. So the good thing about a trademark is it can last forever. It's the only type of intellectual property that lasts forever. Copyright lasts for author's life plus 70, a patent is 20 years, a registered design is 15 years, whereas a trademark can last forever, because if you think about it, it's to do with the business rather than the individual. So if your business continues and you step down as CEO, it doesn't matter that you've left, but the company still exists. You have to renew your trademark every 10 years though. You renew it every 10 years by paying a renewal fee, and again, it's not hugely expensive. The main benefits, so can be used as security when raising finances, you can license it out, you can sell it on. Again, it's a great marketing tool, it's a symbol of your business reputation and quality. If we compare Chanel to Primark, we don't need to go into either of those shops to know the quality and the standard of the products sold by Chanel or sold by Primark. So, you know, they are a good indicator. We call them a badge of origin because it tells the consumer or whoever what your business is, the quality of the business, the reputation. Infringement cases, trademark registration offers a higher degree of protection than common law. So if you can register your company name, then do so. Do so. Other advantages can be linked to higher performance and greater growth. Again, if you're thinking about franchising, you're thinking of franchising the brands, and obviously the logo is really important there. Forces companies to consider their mission statements and their goals to ensure consistency with brand image. And it's the first thing the consumer is aware of, the name, the logo, whatever it happens to be. So it's really important that you get that right. So brand value equals shareholder value. So a brand is a name, a symbol, a design or mark that enhances the value of a product beyond its functional purpose. You know, we consider many things when we purchase goods or services, and we make distinctions about brands, whether it's coffee, whether it's a supermarket, whether it's retail, it doesn't matter. Sometimes it's to do with pricing, sometimes it's to do with quality, sometimes it's to do with geographical location. but it's really important that that brand, that symbol tells us what it is we need to know. It's based on versatility. It's to do with value to the customer and value to the owner. Okay, so I mean, I don't know how big you want to grow your business, but your brand is going to be really, really important. Criteria on which a brand valuation exercise is based. Is it separately identifiable from the product itself or the business itself? Is it protected legally? Is your business protected legally? Is it transferable? Can you transfer your brand to something else? Can you diversify your brand? Is it enduring in nature? So all of those things are quite important if you're thinking about the value of your business or your product. So IP management and due diligence. So we've moved on from the different types of intellectual property that are out there, which obviously, you know, as I said, most of you will have at least 2 of those that are relevant to your business or your future business. Due diligence, ownership, license to use all the IP used. This is really important. So if you're the owner, you can license, and you can license all of the IP or some of the IP. Proper registration of owned IP. So where you can register your IP, i.e. your trademark, your design, your patent, do so. Copyright notices on all original works. So again, just your name, the year of creation, and the symbol, because that is a deterrent from anybody. That's looking after your IPs. This is all about how can I protect my IP in a business world where, you know, it's very easy to steal and infringe other people's intellectual property. So if you can and you want to, license it, because that brings in extra revenue for it. If you can't register your IP because it's copyright, then make sure that you've got your name, the year of creation, the C symbol on all of your work. If you can't register your trademark, have the TM sign next to it. If you can register your trademark, do it. As I said, it literally costs a few £100s. It's a very easy form to download, and it just gives you that extra protection. If you're in the business of patents, make sure your patent fees are up to date. So all of this is about, you know, housekeeping. It's about looking after your intellectual property and obviously your business. Okay, technology transfer. And this is for all types of intellectual property. Assignment, and that's the same as selling it. If I assign my IP, whether it's a patent, whether it's a trademark, whether it's copyright, if I assign it, I have sold it. I now have no right to use that IP unless I get permission from the person that I've sold it to. In the same way, if I sell my house, I can't come back in whenever I want. Licensing is different, because licensing is I'm renting it out. So I can rent my house out for a period of time and move back in. It's still mine. The licensing agreement is another word for a contract. So the terms of the licensing agreement are entirely what you want them to be. You can limit the use of the licensing agreement to a geographical location. It can be for a specific time limit. And all of this is exploiting your intellectual property and making more revenue for you. Spin-off companies, again, if spin-off companies are diversifying your product, your goods, your services, think about the IP that attaches to those as well. Again, because are they using the same name, the same brand, the same logo as you? To license or sell or assign. If you license your work, then you retain ownership. Both parties have an interest in the success, because you and the person or persons you've licensed the work to wants to make sure it's successful financially, and can be financial from sale of products. So that's one good way of raising revenue on your intellectual property for your business. Selling. Ownership is not retained. One party may ultimately feel sold short. Licensee may not have cash available. And again, this may not be applicable for a number of years, but if you're going to assign your IP, make sure that nobody else has got a license. So let's say you've given 3 licenses out to people to use your IP. You then want to assign or sell your IP to a fourth individual, be very careful, because you've still got 3 people on license who are licensing your intellectual property. So the legal issues can be a little bit convoluted, but just make sure the contracts are in order. And licensing and selling, licensing and assigning are just forms of contracts at the end of the day. You can assign part of your IP. You don't have to assign or sell all of it. You can assign some of it, in the same way that you can license part of your IP and not all of it. Okay. The licensing process, what license? A patent. Has the application been granted? So again, it depends on what stage you're at before you license. You can license it before the patent's been granted. You won't earn as much money because it can be rejected in a year's time. Excuse me. You can license a trade secret. You can design a design right, copyright, database, and trademark. You can license all of those aspects of your IP. And again, if it's a sole licensee, then it's going to be more valuable to you, because one person will have to pay more than if you had 20 people that you've licensed your intellectual property to. So again, that depends on what it is you want from the license. So why license? Yeah, financial reasons. You might want to develop your product, your goods, your services. So one way to raise revenue, rather than going to the bank and having to pay a huge amount of interest, is to license it. License the IP. It gives you the ability to manufacture the product, because you're giving your license agreement to other parties that can manufacture the product for you. Let's say, you've invented, this is what your business is, it's selling phones. If you give somebody a manufacturer a license, they can then manufacture and export or import those phones to a much, much wider customer base. So that's another good reason to license. They've got the factory capacity and the expertise to do it. So that's your middleman, if you like, or middle person. The licensee has the ability to market the product. You've got credibility in a certain field, in addition to an existing range and distribution channels. So those are all really, really positive reasons why you might want to license your intellectual property. And again, get some good legal advice if that's something you're considering doing, and make sure the contracts are quite tight. I mean, it might be a few years down the line. I don't know, as I said, what stage you're at. Different types of licenses, there's a list of them there: sole, exclusive, non-exclusive, a combination, and sub-licensing. Again, exclusive and non-exclusive, exclusive and sole are kind of the same thing. It means as an IP owner, I'm just giving it to you. You're the only person that can utilize my IP, and you will pay more for that privilege. Or if it's non-exclusive, it means that myself and all of you, I've got 15 of you that I've licensed it to, you can use my intellectual property. I can do a combination of that, and I can allow you as a licensee to sub-license as well. So again, the contract will dictate, and it's all about exploiting the IP, excuse me, and the revenue that you want to generate through this type of agreement. What can you expect in terms of payment, or can you pay out? If you yourselves may be licensing IP from someone else. Royalties, that's pretty common in copyright and patents, and that will be a percentage. Again, the contract will dictate whether it's 5%, 10% of every, for whatever it is. Staged payments, you can be paid more with patents. You can be paid in stages. Patent and other registration costs, you can actually mortgage your patent in the same way you can mortgage a house as well. You can pay consultancy fee, upfront payment, shares in the company, and other options. So these are all the types of payments that you can expect to receive. The most usual, though, are royalties. The others are pretty specific, depending on the type of IP and what you're doing with it. So you can expect royalties, and that's just another term for payment. The licensee's expectations. What would the licensee expect if you were to license your IP? What does the other party expect from the licensing agreement? Well, to be able to operate the invention, if it's a patent, to have the inventor's cooperation, to use its commercial judgment in terms of the intellectual property, and to be able to add its own intellectual property. So not just use yours, but also use their own intellectual property. Again, it depends on the type of IP that you're talking about. So in terms of payment for royalties, how does that work? Well, it will vary, but you can get per unit sold, as in the music industry. So if it's being streamed on Apple or iTunes, it can be 1 penny every time, which doesn't sound a lot, does it? 1 penny for every time the tune is played. Payment based on licensee's profit, so you can have the profit at the end of the year. Payment based on licensee's sales, minimum annual royalty. So, and again, it's entirely up to you as to the type of payment possibility that you want from the licensing agreement, but these are just examples. What's the pitfalls of licensing? Right, who owns any improvements made? If it's a patent, let's say, who owns the improvements? And again, the contract has to be very clear. You've got as to who owns what. If it's been developed, was it using your IP? Can you claim any rights on that? Again, so you must make sure that your contract is clear on that. Can either party assign or sublicense? So if you have a sole license from me, I can't use my IP. If it's an exclusive license, it means only you can, I've only licensed it to you, but I also can use my IP. So this is important as to whom is able to use the intellectual property once it's been licensed or assigned. What are the rights to terminate? Now then, with any contract, termination is written into the contract, so you have to do the same for a license or an assignment. So termination, 3 months, 1 month, 2 weeks, whatever. When are the payments due? How often do you want them? Is there any guaranteed payment? What are the licensor's inspection rights? And again, that will depend on whether there's processes and products in factories, etc. What rights do you have? What are the restrictions on related companies? If you've got spin-off companies or you're working in conjunction with somebody else, I mean, I don't want to assume that you set up your businesses on your own. You could be working with other people here. So the licensing agreement may impact on that. What happens if the invention is unsuccessful? Who forks out then? Who pays the bill there? Who is responsible for the patent costs? So those are the pitfalls of licensing. In most situations, licensing is very, very, very straightforward. It becomes more problematic with the patent though, because there are other things to consider, and it becomes a bit more problematic if there are third parties involved in the business startup or the business itself. And finally, any questions? So I know it's been it's been a broad spectrum of what we've covered in the session today, but hopefully I've given you a little bit of insight in the exploitation of intellectual property, the different types of IP, and hopefully you'll be able to align it to the business or the business setup that you're actually doing at the moment. So yeah. Oh, that's good timing. I said it'd be about 1 hour and 15 or 1 hour and 20. Questions? Any questions for me about anything that I've covered or anything to do with your business itself? Yes, Callum. Hi. Is your mic on? I don't think your mic's on, Callum. Or did you put your hand up accidentally? Hello. Oh, sorry, he's trying to get his mic to work. Okay, while you do that, has anybody got any other questions? Jessica, can I copyright register the process of how I make my textiles and furnishings? If it's a process, you can. That will come under a patent though. So if it's a process can be registered as a patent. I use machine knitting to create upholstery and patterns. Can I protect my process from others? Only if it fits within the general description of what a pattern is, then you can do it like that. It's going to be quite costly for you to do that though. Machine knitting to create upholstery. Yeah, and then so what you could have there is the process can be protected as a pattern, and then the designs are protected as artistic works under copyright. Is your mic working yet, Callum?
Yeah, I think so. Can you hear me? Sorry, that took a while. I've got quite a specific question about my idea is basically I've designed some artwork and I'd like to get that produced into pin badges and then sell the pin badges. But I've looked at a couple of companies that produce the pin badges and they ask for it in a digital format, but I don't at this stage have the digital software to do that. So you can submit just the sort of a scan of the artwork, but then they'll create it digitally. But then I don't know whether that means they'd have equal rights to it as me, or whether.
Yeah, I think what you would need there is, so what they're doing is they're changing it from one medium to another, and that is an adaptation under the Act. So they can't do that without your permission. So if you give them permission to digitize your artwork, you need to make it clear that the artwork in its digitized format and its original format still belong to you.
Okay.
And as long as they agree to that, there's no problem.
Okay, fab. Excellent. Thank you.
Welcome. Any other questions or queries? No? Well, I hope you've found it useful. I hope you found it interesting. I think if you've got any questions or queries, you think about them, then forward them to the team and they can pass them on to me. And I don't know whether you'll be back in situ in Salford over the summer or in September. Are you all based in Salford? Jessica, are they all based in the hub?
Some of them aren't. So we have opened the events up to general public alumni, but we are trying to support people on launch that aren't even in Salford. So if you are a student of Salford or an alumni, you can send us a query and we can pass it on to Parveen.
And also, once we're back in, if you're there, I mean, I'm just along the corridor from you anyway. If you are back in Salford and you're actually on.
Oh, fab. Oh, okay. I actually live, I don't know if you know the old Adelphi building. I live right next door to that.
Oh, do you?
Yeah, get to stare at it every day.
Yeah, so I'm actually on the same floor on that corridor. So in the past I have had people just knocking on, and I don't mind that. So if you're around and about, and you've got any questions or queries for me, I will be back in from September. We're all back in, aren't we? So do feel free to knock on. I will only take a small commission for any help.
I'll give you a cushion if you want. If you want a custom cushion,
I'd love that. Love that. Just for me with my own design.
Exactly. That is part of my business actually. So you can be a test client.
Oh, I love that. That'd be super. Okay. Well, is there anything else from anyone else? If not, then thank you so much. No one else got any other questions? No?
If anyone has got any questions, you can email them to us at launch. This recording will be available as well in the email, if that's okay, Parveen. So if you think of anything, please let us know. And thank you for attending. And thank you so much, Parveen. This has been a really helpful session.
Oh, I'm glad you enjoyed it. Thank you so much.
Thank you.
Take care, everybody. Oh, thank you. Welcome. You're welcome, Callum. So have a good summer, everyone, and enjoy the rest of this amazing festival. Take care. Bye.
Thank you. Bye.
Bye.